Hello everyone, welcome to a brand new video of mine in a perfectly outdoor setting, the beautiful city of Windsor, Ontario. And behind me you can see the city of Detroit by the waterfront. So, so a couple of days ago I was talking to one of my friend. He happens to be quite a quite a source of knowledge and in the field of cloud. So this video is a result of that conversation and my experience, and which I thought to compile out here. So what is there that generally cloud has been there for some time now, and certain things like scalability, no volume commitment, and things like that, they have been negotiated or spoken about ad nauseum. Like they have been overkill of that. We know, everyone knows about those things. But generally, one point is that what are what are the things which can be reasonably negotiated, and what are things which are kind of red lines, which just cannot be negotiated in general contracts with any SaaS supplier, with any cloud supplier. And when I say cloud, I immediately mean all three of them: SaaS, software as a service; PaaS, platform as a service; and IaaS, that's infrastructure as a service. So I thought of compiling few of the items which can be tailor-made and which cannot be tailor-made. Of course, there's nothing like drawn in a line in the stone. Things can change, but yeah, that's the kind of a general overview I thought of presenting it to you, and I hope you'll like it. So one of the top items which can be tailor-made is IP indemnification. So IP indemnification in a cloud services environment is where the cloud service provider is going to indemnify you for any of the IP infringement claims arising from a related or unrelated third party, which may result in the cessation or impeding or whatever, or the business can effect of the client. So that can be reasonably ascertained, that who would indemnify whom, and that can be taken care of by the next commercial clause. That's the limitation of liability insurance and things therein. So IP indemnification is a relatively a low-hanging fruit, which can be taken care of. The second one again from IP, is the claims arising, whether it's global claim or from the place of performance. So that's also can be taken care of. The third is termination. So termination rights is a bit of a tough thing, but yeah, termination rights, termination for convenience, can be negotiated reasonably easy to moderate level. Although the cloud service providers, they have a thing for ASC 606 revenue recognition, and they have their own concerns around that. But that said, still the room lies for negotiation, and negotiation can happen on that. The another point, that's the third one, is the lost profit. The lost profit is where, because of the malperformance or misperformance or non-performance by the cloud services provider, the profits are affected. And if the profits are affected, then the cloud services provider has to indemnify the client. So that is also one of the moderate items. Although it's the cloud services provider do drag their feet, because they have small to big, many kind of different clients on their cloud space. So, but that again depends on case to case and on the contract value. The another point is the data center specifications. and 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 as a client, it's a paramount importance to know that where the data is going to reside. The data can reside within the country, outside the country, within the province, outside the province, or in certain, if I can use the word, difficult kind of jurisdictions, or where the government is too um, not too respectful of the legal processes and the contracts, and they can kind of act as a big boy in accessing the data which is stored overseas. So that is one of the things which can be easily ascertained, if not controlled, but definitely ascertained before signing a contract or negotiation. So the next point is also a branch arising out of that, is not to access, like a need to access data. So as a matter of fact, uh, uh, the data can be accessed by the user, or the client. So that is one thing which can be at least ascertained, if not negotiated. Then the other point is the governing law. The governing law, again, this is a moderate point, where the vendor where the cloud provider may say that we want to have a uniform set of legal outcome, or the governance of the contract, in terms of where the contract would be governed. So it can be the state of California, or the court systems of British Columbia, or India, or wherever. So, but again, as as uh, as a client has this is, I would say, a bit of a low hanging fruit, again, in terms of negotiation of a cloud services contract. So, but again, the ramifications of turning a blind eye to this particular clause is can be moderately to quite high in case of litigation. The other one is insurance. Insurance is where the cloud services provider agrees to cover the contract for certain amount of liabilities, like commercial or general liabilities, and so on and so forth. So that is also one of the reasonably easier clauses to negotiate. And then we have volumetric pricing. Again, that's, as I said at the start of the video, that has been more of an overkill. But yeah, volumetric pricing can be negotiated with relative ease and effort. And finally, we have limitation of liability. Now, I don't know what to say about this. It is easy, it is not, maybe not. But one thing is for sure, that it always pays to have that quantified, and certain call outs, like data breach, confidentiality, privacy, negligence, misconduct, and those kind of things should be uncapped, in addition to the liability claims arising from commercial and general damages. So that is actually the things which can be easily or moderately tailored for in a particular contract, in a cloud services agreement. Now comes the things which is difficult, and at times it's kind of infructuous. Like, even if you're negotiating, at the end of the day, the performance or the legalities around that will make that infructuous. That so quickly coming to what you cannot is the individual SLAs. Now, service level agreements are actually a a mainstay in traditional technology contracts. But in terms of where your data is there up like in the remote environment in the cloud, so that becomes a tough nut, and kind of, like I use the word infructuous. It becomes a bit of a thing which cannot be reasonably enforced, operationally enforced. The second one is escrow. Like, I know most of the companies, they're very hungry for escrow, and that's a completely different topic. I would love to make a video on that sometime later. But escrow is a thing that, in case of bankruptcy or any kind of a problem with the cloud services provider, the cloud services provider agrees to place the source code of itself of uh, of the particular software or in with one of the escrow agents. Now, this is easier said than done, because any particular cloud services provider would have thousands and thousands of, if not thousands, hundreds of different clients. So it cannot be giving its escrow, like its source code to an escrow agent to be given to 100 different, um companies. So again, an infructuous clause, and I think it'll be a wild goose chase to try and negotiate that. The other one is a DR. Now that sounds like disaster recovery. That sounds like a bit of a easy thing, but in reality, it's not. A disaster recovery would be there in big cloud services provider, but to say that some cloud services provider is gonna have a special disaster recovery only for you, only for a particular client, sounds a bit outlandish. That it'll be a difficult thing. And then the again, the governing law, and like I said, the governing law can be on both sides. It's easy and it's not easy. I had honestly a difficulty in placing that in can and cannot, because at times the governing law is superseded by applicable law, so that becomes super difficult thing to change. Now, applicable law and governing law is how they're different. Applicable law is the place of performance. Now, in a contract, if the parties have negotiated the governing law as laws of the state of New York, but the data center or the actual place of storage of data is say India. Now, in that particular case, the applicable laws would be the laws of the land, where the place of performance is India. Though there can be litigation, interpretational issues, whether it should be the place of performance or whether it should be the place of consumption. But again, that becomes a difficult thing on negotiation of governing law, and whether it's going to be superseded by applicable law. So there is a bit of a haziness out there. So this, and then comes IP rights. Now, IP rights is, of course, if someone is having a cloud services agreement, then IP rights would be pretty much almost like I said, for escrow, for just few. A cloud services provider will never give its IP rights to you, to a particular client, just because it's buying like 5,000 or 500 or even 50,000 licenses, because that is its bread and butter. So that is another thing which is difficult to negotiate. And finally, I have audit. The audit is again a kind of is viewed as a very intrusive activity uh, that that a cloud services provider would actually have nerve chills to just think that there would be like 50 different clients or 100 different clients. They would be actually walking in their premises and performing an audit or even remote audit or anything like that. So we have to like in case of audit, uh, uh, what can be contended with is with certain certifications and SSA 16 or PCI DSS compliance and things like that. But actually gaining a kind of an intrusion or intrusive rights to commit to do a physical audit is is a tough thing, and at times it can be infructuous because it can be overruled by a by a particular statute or anything like that. So these were the items what I think can and cannot be reasonably negotiated um in a cloud agreement. And I hope you like that, and do feel free to drop in your comments. And this video I made in the memory of my father, whose birthday I am observing today. So take care, and I'll see you around in the next video. Till then, bye bye.